you were saying in your statement that it would have been difficult, if not impossible, to prove the actual amount embezzled by Mr. Quarm. And you say, given that the Horizon audit depended largely on the bogus figures inputted by him, if the case had gone to trial, you would have had to rely on evidence from his admissions as to how much he considered he'd embezzled and the period over which he considered he'd been operating falsely, and other evidence such as such as average takings over previous years.
Yes.
Why do you now wish to delete that?
On consideration, I just realised that wasn't the case.
You previously thought that proof of the case at trial was reliant on Mr. Quarm's admissions.
That's right.
What caused you to think that proof of the case at trial was not reliant on Mr. Quarm's admissions?
Just once I got into considering it in more depth, as I was mulling it over since I first made this statement in December, I realised that was probably not the situation.
Okay, we'll come to what other evidence there was to prove the amount alleged to have been embezzled by Mr. Quarm a little later. And then is the fourth amendment that you wish to make on page 8. And that's paragraph 19. You're here dealing with Mr. Quarm's interview, is that right?
That's right.
And you say the things that he said, it was difficult to treat them as serious challenges, given that Mr. Quarm admitted taking cash coming into the post office branch. And then the words equivalent of around £4,200 every week for an unknown period, but conservatively estimated to be 10 or 11 months, and without putting it through his till. Do you wish to delete those words?
I do.
Is that because you realise that, in fact, Mr. Quarm did not make such admissions in his interview?
That's effectively right.
So that I can be clear, there should now be a full stop after branch, is that it? And then the rest deleted, the rest of that sentence deleted.
That's right.
Yeah. Thank you.
Is that because you reread his interview and realised that the admissions that you attributed to him there, he hadn't in fact made?
Effectively, yes.
Thank you. With those 4 amendments brought into account, are the contents of the witness statement true to the best of your knowledge and belief?
They are.
And is your signature there on page 12 to attest to that fact?
It is.
Thank you very much. That can come down, the witness statement. Now, Mr. Teale, you're the first Scottish prosecutor that the inquiry has heard from who has been involved in the prosecution of a sub-postmaster where evidence provided by the post office was the basis for the prosecution. I want to ask you, therefore, some questions about the approach that the Procurator Fiscal Service and you took to such cases.
Indeed.
Understand? And I think you're no longer a Procurator Fiscal, is that right?
That's right.
And that role ceased for you in June 2015, is that right?
That's correct, when I retired.
But you remain a practicing solicitor, is that right?
That is right.
In terms of your background, you qualified as a solicitor according to Scots law in 1980.
Yes.
You then went into private practice, is that right? But then in 1982, you joined the Crown Office and Procurator Fiscal Service as a Procurator Fiscal Depute.
That's correct.
In 2000, you were appointed, is this right, Procurator Fiscal for the Western Isles?
Yes.
And does that include the, within its jurisdiction, the Sheriff Court district of Lochmaddy?
That's correct.
And within that jurisdiction was the post office owned and operated by William Quarm situated?
It is.
Can I turn then to your involvement in prosecutions involving sub-postmasters before the prosecution of William Quarm? In your witness statement, there's no need for it to be displayed, you say, over the years, you would have received and considered many reports from the post office regarding criminality by their workforce.
That's correct.
You say that, quote, I found their reports were straightforward and I cannot recall any instances where there was any suggestion that the information provided was misleading. I cannot recall any other post office case considered by me which relied on data from the Horizon system. So are you referring there to receiving and considering many reports about the post office workforce to your many years of experience as a Procurator Fiscal Depute?
Yes.
And was that in busy offices in Glasgow, for example?
Correct.
And Greenock as well?
And Greenock.
With that experience in mind, and also borrowing some of your knowledge on some legal issues, can you help us on these 4 topics? Firstly, the law of corroboration in criminal proceedings in Scotland. We've had described to us the cross-reference is paragraph 4 of the witness statement of Kenneth Donnelly. I think you would know Mr. Donnelly.
I do.
He is presently the Deputy Crown Agent for Specialist Casework at the Procurator Fiscal Office. And he says there must be evidence from at least 2 separate sources, corroboration, to establish that a crime known to the law of Scotland was committed and that the accused was the perpetrator.
That's correct.
Is that a fair summary?
Very fair.
And so for all of the period that we're looking at, say from 2000 onwards until your retirement in June 2015, was that the position?
Yes.
Would you therefore expect that to be something which was addressed in the reports submitted to you by specialist reporting agencies, including reports from the Post Office?
Yes.
Because if that's the law, it needs to be confronted, doesn't it? It needs to be addressed.
It does.
And just on specialist reporting agencies, is it right that that's a term of art within Scotland? An SRA, a specialist reporting agency?
Yes.
And are there a number of those?
Quite a number.
I've seen a figure of 172 presently. Does that sound about right?
That wouldn't surprise me.
One of those is the Post Office.
Correct.
And so if that's something, the evidence that satisfies the Scottish law of corroboration, that you would expect to be addressed specifically in a report submitted to a Procurator Fiscal, that would be something which you, as the Procurator Fiscal, would wish specifically to address in your decision-making.
Correct.
And so when you're deciding whether to commence criminal proceedings against an individual, you'll want specifically to address the issue of where is the corroborative evidence.
Correct.
Now, although I'm getting ahead of myself a bit here, I think it's right that that issue was not addressed in the report submitted to you in the case of William Quarm.
No, I think it was addressed.
Head on, did it say, we understand that there is a requirement for there to be corroborative evidence, and the two pieces of evidence that we, the at least two pieces of evidence that we rely on to satisfy that test are as follows?
Well, I don't think it said that in these words, but the body of the report indicated that there were two sources of evidence.
Were there two sources of evidence?
From the report, yes.
And what, again, we're getting ahead of ourselves a bit, but just at this point in time, can you identify what the two sources of evidence were?
Yes, there was the audit the evidence of the shortfall,
And what did that show?
that there was a shortfall of £40,000.
Which crime did that show had been committed?
Altogether, the evidence was
No, just that one. Which crime did that show that had been committed? The fact that there is a shortfall.
embezzlement.
So on its own, the fact that there's a shortfall is evidence that there has been embezzlement.
No, maybe it'd be easier if I just explain what I took from the report. Of course, I was looking for corroborated evidence from two sources, pointing A to a crime having been committed, and B, that it was the accused who was the perpetrator. Now, the evidence for both of these came from the evidence that an audit had disclosed a shortfall of £40,000. And the second source of evidence was his admission that he had been taking funds from the post office and using them to prop up his retail business.
And how much had he taken and how?
He'd taken £40,000.
He admitted to taking £40,000, did he? In your mind?
It would probably be easier. It would be easier to look at precisely what he said.
Okay, we'll come to the
rather
interview.
than taking it as a generality.
Okay. But in your mind, there was an admission to taking £40,000, correct?
No, the audit had indicated that there was a shortfall of £40,000.
Now, am I right that none of the available documents that you have record contemporaneously what the two sources of evidence that you considered to exist to amount to corroboration were?
No, I'm sorry, could you repeat that
Yes.
question?
There's no contemporaneous document recording your decision-making on why this was a case that should go for prosecution?
No, you mean my minutes, which I would have made on the case file. Is that what you're getting at?
Yes.
No, there isn't. At least as far as I know, I haven't been presented with any such document.
You mentioned minutes on a case file. At this time, would this have been electronically or would it have been by paper? That you make a minute of your decision-making?
I suspect by paper.
By paper.
This is 2008 we're talking about.
And so would you record, how much of your decision-making would you reduce to writing in a case like this?
Anything that I considered to be important in the decision-making process. Sometimes it's perfectly obvious and you don't have to say anything.
So there would be nothing?
Well, I don't know whether there was anything or not.
No. In such a case where it's perfectly obvious that you don't have to say anything, you would literally write nothing down?
You would just write proceed sheriff summary or proceed by petition or whatever.
And what about a case like this? Would you isolate the evidence in the way that you've just done? There were two pieces of evidence that amounted to corroboration here. They are the shortfall shown at audit plus the admissions in interview, something like that.
Possibly something like that.
But we should be able, if those minutes still exist, we should be able to find a record of your contemporaneous thought process.
There might be something. It seemed to me pretty obvious on rereading it in December of last year what the evidence was to proceed. So whether or not I would have been equally satisfied in 2008, I just don't know.
Can we turn to the second issue I want to ask your assistance on, please? Namely the test that a procurator fiscal applies when deciding whether to commence criminal proceedings against an individual or not. Is it right that that's governed by a document called the Crown Office and Procurator Fiscal Service Prosecution Code, or the Prosecution Code for short.
I don't know if there was a prosecution code in 2008.
I think we got one that starts in 2001,
Okay.
the first edition of it. Was that a document that you would have at your fingertips?
You mean physically, or just know what it's about?
Yes, either or both.
Oh, yes, of course.
Can we look at the one that has been provided to us? WITN 1051-0101. Thank you. You can see this was first published on the 1st of May 2001, but it was updated last year in July. And it's not possible to tell which parts have been the subject of amendment between those two dates. So I'm not saying that this was in these precise terms applicable when you made your decision in 2008, but I just want to get your evidence, please, on the test that Procurators Fiscal applied. If we just look, if we scroll down, please, and look at criteria for decisions. Thank you. In considering the action to be taken in relation to reports of crime, the prosecutor must take account of both legal and public interest considerations. Is that a familiar distinction to you?
Yes.
So is it right that in Scotland too that there were two elements to the test?
That's correct.
Okay. And then under the heading legal considerations, in considering cases, the Procurator Fiscal must decide whether the conduct complained of constitutes a crime known to the law of Scotland and whether there's any legal impediment to prosecution. For example, it may be necessary to consider the effect of any delay, and then something about international law, and then evidential considerations, sufficiency of evidence. The Procurator Fiscal must be satisfied that there is sufficient admissible evidence to justify commencing proceedings. In general, for there to be sufficient evidence, there must be corroboration. That is evidence from at least two separate sources to establish the essential facts of the case, i.e. that the crime was committed and that the accused was the perpetrator. And then we see reference to the burden and standard of proof. The prosecution must prove these matters beyond reasonable doubt. And then there's a bit about the sources of evidence, and then if we move on, please. We then see that the prosecutor, under these next three headings, before we get to public interest considerations, is directed to consider admissibility, reliability, and credibility. So admissibility, laws of evidence determine whether a court can consider certain types of evidence. The prosecutor will assess whether, having regard to the laws of evidence, the court will allow the evidence to be considered in the case. And then reliability, although there may be sufficient admissible evidence to justify criminal proceedings, consideration must also be given to the reliability of that evidence. This involves an assessment of the quality of the evidence. And then credibility. As with reliability, the assessment of the credibility of evidence is ultimately a matter for the court. However, there may be doubt about the credibility or truthfulness of a witness's evidence, etc. Are those three things, admissibility, reliability, and credibility, things that when you were making decisions as a Procurator Fiscal, you consistently addressed?
Yes.
And On reliability, would you accept that if your case is founded on evidence that's produced by a computer, then it's necessary for the prosecutor to consider the reliability of the evidence produced by that computer?
Yes.
Now, the document then turns to consider public interest considerations, which I'm not going to address with you. What the prosecution code does not do is describe the test that a prosecutor must apply when deciding whether to commence criminal proceedings or not. Do you understand? It says the things you must address are evidential sufficiency and public interest, but it doesn't say what the test is that a prosecutor must apply. What was the test that the prosecutor must apply?
I don't know. I'm sorry, I just don't know what you're saying, what you're asking me.
Well, in England and Wales, a prosecutor is directed, and has been for the last 2 decades, to be satisfied that there is a realistic prospect of a conviction. And the code in England says that a realistic prospect of a conviction is an objective test, and it explains that realistic prospect of conviction means that a jury or a bench of magistrates, properly directed in accordance with the law, will be more likely than not to convict the defendant of the charge alleged. So there's an explanation of the standard that must be achieved in the prosecutor's mind in order to commence criminal proceedings.
Well, that doesn't exist in that form in Scotland.
What test was applied?
Public interest.
No, that's the public interest is addressed whether separately in the document, whether, for example, proceeding is in the interest of the victim, the accused, and the wider community, and matters of that sort. I'm asking about the evidential sufficiency part of the test. What test was applied?
There isn't a test as such, as I understand it from what you're asking me.
Well, what approach was taken then?
Well, we look at the evidence. We look at the evidence and judge: is it admissible? Is it reliable? And is it credible?
And overall, is there a compendious approach that you take when you've done those things? I think there's enough evidence to go ahead. I believe there's enough evidence to go ahead. I guess there's enough evidence to go ahead. I think it's more likely than not that the accused will be committed. I'm fairly sure that that's so. I'm certain that that's so. Was there no fulcrum around which the issue turned?
No, you're very much guided by what the report tells you. And in that you assess the quality of the evidence and whether there's sufficient evidence, sufficient corroborated evidence from 2 sources pointing to the facts that the crime has been committed and committed by the accused.
What I'm trying to probe is it's correct then that in Scotland there was no test that was applied across the Procurator Fiscal Service so far as you are aware that ensured consistency of decision making so that everyone had a datum point past which the evidence must pass in the prosecutor's mind before proceedings were commenced?
No.
What test in your own mind did you apply? I think this case will succeed. I believe this case will succeed. I suspect this case will succeed. I'm pretty convinced this case will succeed.
No, likelihood of success doesn't come into the decision whether to prosecute or not.
That was an irrelevant consideration, how likely it was that the evidence was sufficient to establish guilt.
There's some cases that you would take up that you would think, you wouldn't say, I'm bound to succeed in this case, or I'm doubtful whether it'll succeed, so I won't take it up. If they're sufficient and it's in the public interest to prosecute, then by and large, you would take that decision to prosecute.
Very well. That can come down, thank you. Thirdly, can I ask you about... sorry, that can come down from the screen, thank you. Thirdly, can I ask you about computer evidence in Scotland? What was the law regulating the admissibility of evidence produced by a computer before 2015, the year that you left?
I don't know of any such evidence.
You don't know of any such law? Do you?
Law, yes, I beg your pardon.
Is that because you never addressed your mind to it? Or that you know positively that there isn't such a law?
It's because I haven't addressed my mind to it.
You've told us that in a number of cases you considered files that were submitted by the Post Office as a specialist prosecuting agency.
Yes.
Did a number of those rely on computer evidence?
I can't think of any that did.
Other than this one?
Other than this one.
What were the other cases about?
Theft of mail.
So would they be raw mail group cases? So to do with the post rather than the post office?
I suppose if you make that distinction, yes.
And I think you were going to go on and describe some other species of case.
I can tell you that I can't remember any other case which positively relied on computer evidence. I started in Lochmarrie in the Western Isles in 2000, and I certainly didn't receive any post office cases between 2000 and 2008.
You referred in your statement to receiving and considering many reports from the Post Office regarding criminality by their workforce.
Yes.
Which is in paragraph 6. What was the other cases of criminality by the Post Office workforce?
Well, as I say, theft of mail came into it.
And so was that by postmen as opposed to sub-postmasters?
Correct. I can't remember any other postmaster that I was involved in the prosecution.
Did you, outside of cases involving the prosecution of sub-postmasters, prosecute any other cases that relied on evidence produced by a computer?
I can't think of anything.
And so that would have been from 1982 until 2015? No computer evidence in any of your cases?
Well, all I'm saying is that I can't remember whether there were any or not. I'm not saying that there wasn't.
I mean, in that 33-year period, it's likely that there were some, weren't there?
I don't know.
You don't think that there would have been in a 33-year period a case involving a computer evidence?
Listen, I can't remember whether there were any cases involving computer evidence or not.
But in any event, in that 33-year period, you can't recall ever checking what the law was on admissibility of evidence produced by a computer in Scotland?
No.
Can I turn to the fourth topic then, the duty of disclosure? What's your current understanding, obviously we're talking now, but it would have applied to when you were a Procurator Fiscal, of the Procurator Fiscal's duty of disclosure or revelation?
That everything that the Procurator Fiscal receives must be transmitted, must be revealed to the defence.
Do you mean that everything that a Procurator Fiscal receives must be transmitted?
Pretty well everything. I'm being broad, but yes, broad terms.
What's the exclusion then that isn't within the pretty well everything?
suppose if there was something which was deemed, that the police provided, which was deemed
sensitive.
correct.
So public interest immunity material.
Correct.
Can you remember and appreciating it's 8 years or so back since you left the PF, can you remember the test, the approach to disclosure that was the law in Scotland?
No, I think things changed in 2010. I think the 2010 Act provided that there was effectively going to be far greater disclosure than there had hitherto been. It was closely regulated following that.
Well, if I suggested to you for the entirety of the period we're looking at, say, 2000 until after the prosecution of William Quarm, there was a duty to review all of the evidence and information that the Procurator Fiscal had received. Would that be right?
Oh, yes. Absolutely, I would.
And that you would have to disclose information, even if it would materially undermine or weaken the evidence led by the prosecution.
Of course.
And if it would materially strengthen the accused case.
Equally.
And how did the Procurator Fiscal, in a case involving a specialist reporting agency, go about ensuring that that legal duty was discharged?
Well, they have a duty when they report a case to ensure that they're disclosing to the fiscal everything that should be disclosed.
So you're dealing with the report stage at that point, is that right?
Well, no, I'm dealing with the case as a whole, and
Okay.
Yes.
So we're going to come on in a moment to the process by which cases were reported from specialist reporting agencies and then prosecuted. And it seems that there are essentially two stages. One is the submission of a report, and then the documents come later.
That's right.
In stage two. Is that a fair, very high-level summary?
That's fair.
At the first stage, that's when the decision to prosecute is made.
Yes.
And so that's taken, we're going to come on to this in more detail in a moment, not on the basis of the Procurator Fiscal looking at the documents. He or she is looking at a report.
Correct.
So looking at the investigator's summary of the evidence.
Correct.
At that stage, did the specialist reporting agency owe a duty to reveal to the PF material of the kind that we're talking about,
yes,
i.e. material that undermined the proposed prosecution's case or may assist the proposed defendant?
Yes.
And so that was something that has to be in the report.
Yes.
And then when it came to providing documents to the Procurator Fiscal at the second stage, the later stage, again, was that duty of disclosure one that applied to the specialist reporting agency at that stage too?
Of course.
And so it was a continuing duty throughout the life of the prosecution?
Correct. And even after your stage two, throughout the life of the case?
Yes.
That duty?
So right up until trial. I'm not going to come at the moment to duties post-conviction.
Okay.
How, in the report stage, was that duty of disclosure, as a matter of practice, discharged?
It was the reporting agency was under a duty.
That's a restatement of the existence of the duty. So to give you an example,
yes,
in England and Wales, there are a series of forms that the police service have to fill out, and one of them is specifically in relation to this issue. Was there an equivalent in Scotland?
Prior to 2010, no, as far as I can remember.
I.e. a part of the report or a separate document given over to the identification of material that may undermine the proposed prosecution case or advance that of the proposed defendant?
No.
And so in the reports you got, there wasn't a box, a section, an area of the report that forced the specialist reported agency to address that?
No.
Thank you. Can we look, please, at the relationship with the Post Office? And I just want to try and to tap into your long experience as a Procurator Fiscal to hear about the way in which the Post Office and the Procurator Fiscal interacted when the Post Office was acting as a specialist reporting agency. Now, we've been told by Kenneth Donnelly in his witness statement that the Crown Office and Procurator Fiscal Service has been unable to identify any document at all issued by the Procurator Fiscal to the Post Office about prosecutions before the 5th of September 2013. Are you aware of any document, policy, protocol, something written down by which each organisation set out the expectations of the other?
No.
Mr. Donnelly has told us that no specific internal guidance was issued before 2013 that's now been identified, advising how prosecutors were to assess reports and evidence submitted to them by the Post Office. Again, does that accord with your recollection?
Yes, it does.
And so for the 3 decades or so that you were doing this work, nothing was ever written down as to how the Procurator Fiscal is going to address proposed prosecutions by the Post Office?
No.
Now, as we've just discussed, I think it's right that when the Post Office investigator wrote a report to you, I think that was known as a standard prosecution report, is that
Yes.
right? An SPR. And I think after 2006, they were submitted via a web portal, is that right?
Yes.
You've explained that that would not attach the witness statements to it.
It may have, but by and large not.
It wouldn't attach the exhibits or the productions to it.
No.
And so your decision was based solely on what the investigator chose to reveal in the report.
Correct.
Did, to your mind, the investigator have a duty of candour to you in the same way as in England and Wales when one lays an information before a magistrate's court seeking a summons? There's such a duty of candour.
Of course.
In other words, they owed a heightened responsibility to tell you of anything adverse to their case.
Of course.
And so that would ensure, would it, if discharged, that your decision was made in the interest of justice rather than just the interests of the, in this case, Post Office?
Correct.
What safeguards were in place to ensure that the Procurator Fiscal was getting the full picture from the investigating officer in the report?
I don't know if there were any safeguards. It was understood by the reporting agency that they had to have a duty of candour.
They may not summarise all of the evidence, mightn't they?
That's a possibility that they might not, yes.
They might mis-summarise the evidence.
Correct.
They might not fully summarise what an exhibit or the exhibit showed.
Correct.
They might mis-summarise what an exhibit showed.
Correct.
They may not summarise what happened in the interview.
Correct. Properly, yes.
Sorry?
They may not properly summarise what happened
Yes.
in the interview, yes.
I.e. getting over to you the full nuances of what happened in an interview.
If there were vital nuances, correct.
Yes. You wouldn't have any means of knowing that.
At that early stage, no.
So you would have to take it on trust that everything was being done correctly by all investigators in all cases.
At that stage of report, yes.
Were the post office cases directed within the Procurator Fiscal's service to one specific team to consider?
Not in the sort of offices that I worked in, which are remote and manned really just by me.
So they were they weren't all directed to a central office. They were spread across whichever jurisdiction the Procurator Fiscal covered, according to where the branch was situated.
Yes.
Okay. And so there wasn't a process of allocation, that just naturally followed jurisdiction, is that right?
Correct.
And so there wouldn't have been, is this right, any sort of cross-sharing of information within the Procurator Fiscal about issues or problems that the post office cases may have presented?
No.
Do you recall taking cases involving sub-postmasters before the introduction of the Horizon computer system in 2000?
No, I can't recall.
And I think you told us that the only one that you took post-2000 was this one, William Quarm.
Correct.
How would you describe the Procurator Fiscal's relationship with the Post Office when it was acting as a specialist reporting agency, so far as you could see from your, as you said, quite remote jurisdiction?
Yeah, it was fine.
Would you take any steps to interrogate the suggestions and findings presented to you in a Post Office investigator's report?
You mean the SPR?
Yes.
I could, yes.
Would you ordinarily engage with the investigation manager at the Post Office in a dialogue? This is pre-decision to prosecute.
Yes, I could and would if it was necessary.
And what might make it necessary?
Lack of clarity.
Would you typically go back with questions or ask for further inquiries to be conducted?
Well, when you say typically,
Yes.
I've said that I hadn't had any cases between 2000 and 2008, so typically it's quite a difficult question to answer.
What about the cases involving the post rather than sub-postmasters?
They're in the 90s, 80s, I can't remember.
Did you ever engage with anyone other than the investigation manager within the Post Office?
Not that I can remember.
Taking your evidence on this as a whole, would it be fair to say that you worked on an assumption that the Post Office investigator had pursued all reasonable lines of inquiry, including those that pointed away from the guilt of the accused, and had fully and fairly summarised all of the witness and exhibit evidence, documentary evidence, in their report?
Yes, of course.
And you took that on trust?
Yes.
Within the last couple of weeks, Mr. Donnelly has made a public statement on behalf of the Procurator Fiscal Service in relation to the Horizon cases that were prosecuted in Scotland. And he said that the estimation of the service is that up to 100 cases involving Scotland may be affected, and that is a lower number than in England and Wales due to the Procurator Fiscal's policy decisions made in a response to awareness of Horizon system issues. Before 2013, were you aware of any, what he describes as procurator fiscal policy decisions made in response to awareness of Horizon system issues?
No.
When did you first learn of possible issues or challenges to the accuracy of Horizon data?
I can't recall, I'm afraid.
Can you remember how you learned it?
Equally, I can't recall.
Was it before or after you left the service in June 2015?
I can't recall.
Were there communications within the Procurator Fiscal Service before you left in June 2015 in relation to the accuracy and reliability of Horizon data?
Well, I personally can't recall. That's not to say that there weren't. I know that the Lord Advocate addressed Scottish Parliament recently on the 16th of January, and I think she said in that Procurator Fiscals were advised by Crown Office to desist from prosecutions.
In 2015?
I can't remember the
Yes,
dates.
we'll come to that in a moment. I'll give you a bit of detail to help
Okay.
On that. But at the moment, from your memory, can you recall whether any announcement was made before you left in June 2015
I can't remember.
by the service to all Procurator Fiscal deputies, for example, making them aware of possible issues with the reliability of Horizon data?
Well, I can't remember.
What about the other way round? Were you ever asked by the service of your experience of reviewing cases? It would have been limited, I think, to Mr. Quarm's.
No.
Can we look then, please, at WITM 1051-0100? This is Mr. Donnelly's statement to the inquiry, the relevant parts of which were read into the inquiry record earlier. And I'm just going to use this as a basis for asking you some questions about these issues rather than what the Lord Advocate said to the Scottish Parliament on the 16th of January. If we can go to page 13, please. And paragraph 43. I should say that this is a statement made on behalf of the service, the Procurator Fiscal Service. And Mr. Donnelly, on behalf of the service, says that between 2000 and 2013, the Procurator Fiscal Service was not institutionally aware of the bugs and errors in the Post Office Limited Horizon system that significantly impacted the reliability of evidence submitted by the Post Office. And then paragraph 44, he says on the 14th of May, at that time, 14th of May 2013, you would still be employed. Is that right?
Yes.
Post Office, via their Scottish agents, BTO solicitors, contacted the Procurator Fiscal Service to request a discussion about issues with the Horizon Online system. On the 29th of July 2013, solicitors for the Post Office explained to the Procurator Fiscal Service that as a result of the Second Sight and Helen Rose reports, Post Office Limited had instructed their solicitors Cartwright King to carry out a review of all cases reported against sub-postmasters and mistresses, dating from the rollout of Horizon Online in January 2010, in cases where a sub-postmaster had raised an issue with either Horizon Online or their training of the system. Both the Second Sight and Helen Rose reports were being disclosed to the defence by Post Office Limited, BTO solicitors then advised the Procurator Fiscal Service that it would be reviewing all the Scottish cases that could be affected by the issues identified in these two reports. On 9th of August 2013, the Procurator Fiscal Policy Division made senior Procurator Fiscal Service officials aware of the developments and asked that information regarding the issues with Horizon Online be passed to prosecutors dealing with ongoing reported cases. So in summary, Mr. Donnelly is telling us that in 2013, Post Office solicitors told the Procurator Fiscal Service about some challenges around the Horizon evidence. Yes?
Yes.
You were not, I think, present in any of these meetings. Were you told about the fact that they were taking place or the issues that came out of them?
Not that I recall, no.
Were you told about the second site review?
No, not that I recall.
And the Helen Rose report?
No.
And the last sentence, the policy division made senior officials aware of the developments and asked that information regarding the issues with Horizon Online be passed to prosecutors dealing with ongoing Post Office reported cases. Did that happen to you?
I can't recall.
Okay. Were you in fact in 2013 dealing with an ongoing Post Office case or not?
No.
You weren't? Okay. Were you aware of the instruction of BTO solicitors in 2013?
No.
Can we move on, please, to paragraph 45? If we just scroll down, we're moving to later in the year in 2013. On the 5th of September, a meeting took place between the Post Office, BTO solicitors, that's the Post Office's Scottish solicitors, Cartwright King, that's their solicitors for England and Wales, and Crown Office Policy Division officials at the Crown Office in Edinburgh. Cartwright King's senior counsel, Simon Clark, was in attendance. At the meeting, BTO solicitors explained that it had carried out a review of all live Scottish cases and had determined that the Horizon system defects identified in the second site and Helen Rose reports did not play a part in any live Scottish cases, save for one. BTO's review processes assess cases as Type A or Type B. Type A, in which Horizon had provided the information as to wrongdoing, but was not the provider of primary evidence. In almost all of these cases, the sub-postmaster had admitted to the taking of monies belonging to the Post Office for their own unauthorised purposes. Type B, where Horizon or the training of its use had been raised by the sub-postmaster. Cartwright King and BTO solicitors advised that only Type B cases were cases which, in their view, required disclosure of those two reports. BTO's review concluded all but one live Scottish case was Type A, and that all concluded cases were Type A cases which did not necessitate further review or disclosure. Was that communicated to you that this distinction between cases existed, that they were to be treated differently?
Not that I can recall, no.
And you didn't have a case on your books at the time?
Correct.
You can't recall any memorandum or edict coming out from the centre about the treatment of a Post Office case if one was to land on your desk?
No.
Okay. Were you equally asked to provide any details of all cases which you had as ongoing?
No, I don't think so.
If we move on to paragraph 47, please. Post Office Limited advised the Procurator Fiscal Service that a full examination of the Horizon system would be undertaken and would be completed within 6 to 8 months. I take it that kind of information wasn't fed down to you either?
No.
And paragraph 48, in the light of these revelations, an instruction was thereafter circulated within the Procurator Fiscal Service for prosecutors to consider Post Office reported cases on their facts and circumstances, over the page, in determining whether they should be adjourned pending the outcome of Post Office review. The Procurator Fiscal Service did not terminate all Scottish Post Office cases. Can you remember that kind of instruction or memorandum coming out?
No, I can't.
Paragraph 50, ultimately it's understood that Post Office did not commission a second report, as had been discussed. Post Office Limited subsequently advised the Procurator Fiscal Service that despite consulting with academics, a further interrogation of Horizon Online system was not possible. Moving on, paragraph 51, please. 6th of October, there was a meeting. By then you'd left, is that right?
Yes.
So 6th of October, you had left the service by then. I'm not going to ask you about anything there. It seems that up until the point you left, from when the first date that this statement talks about a revelation occurring in May 2013, there was a form of ongoing dialogue between the Post Office and its various solicitors on the one hand and the Procurator Fiscal Service on the other. Was any of that revealed to you as a Procurator Fiscal?
No.
And as I've said, you weren't asked to make a return to establish whether or not you were prosecuting any cases?
Not that I can.
In fact, you weren't. In fact, you weren't prosecuting any such cases then?
Correct.
Okay. The system that was by then in operation, a web-based portal as I've described it, for submission of reports, I think that had, is it right, a unique identifier for each of the specialist reporting agencies?
Yes.
Would it be possible for somebody at the centre, as I'm calling it, i.e. in the Procurator Fiscal Service, to identify how many cases there were that were being put before Procurator Fiscals by the Post Office?
I can't answer that question.
I'm just trying to understand whether it required positive action by the centre to come out to each of the Procurators Fiscal to find out whether you had a case on your books or whether they could tell from the computer.
I don't know.
You don't know. Okay, thank you. Thank you. Can we turn, please, to the prosecution of William Quarm? That can come down from the screen, that witness statement. I think overall in your witness statement, would this be fair? You seek to convey the view that the prosecution of Mr. Quarm was carried out entirely in accordance with the applicable law and practice in Scotland and raised no concerns for you whatsoever.
That's correct.
And does that remain the case?
It does.
Can we look, please, at your witness statement at paragraph 11, which is on page 4. If we scroll down, it's at the foot of the page. You say, it goes almost without saying that the Procurator Fiscal will inevitably rely on the accuracy of any such report, and there we're dealing with the report submitted by the Specialist Reporting Agency to the Procurator Fiscal, inevitably rely on the accuracy of any such report on which to base his decision. And it's well accepted, he's entitled to rely entirely and absolutely on its accuracy for justification of any consequent actions taken by him. And so that is a reflection, I think, of the evidence that you've given to us already about total and utter reliance on the Post Office investigator. Does that mean that the level of scrutiny that the Procurator Fiscal could in practice apply at the point of deciding whether to prosecute was somewhat lacking?
I wouldn't go as far as that. It certainly got the potential for problems arising if there is lack of candour.
But in England and Wales, for example, police officers produce a summary of the evidence to a prosecutor on a document called an MG5. And many, many prosecutors, indeed members of the bar as well, would say, and indeed are taught, don't rely on what a police officer says the summary of the evidence is. Go and read the evidence. Look at the witness statements, read the exhibits, read the documents, see for yourself what the evidence actually shows. Not rely on somebody who might have a vested interest in presenting a rosy picture, might say. That was an impossibility for you at the point of prosecution.
At the point of raising the prosecution, it's not an impossibility, because if there was some doubt about any aspect, you would of course go back to the reporting officer and ask for clarification.
That's only if the way they had written the document.
I beg your pardon?
That would only be if the way they had written the document raised an issue.
Well, no, it might be apparent by virtue of lack of saying something.
You continue, if there were ever any concern by a reporting officer in any agency, whether the police, the DWP, the SSPCA, I think that's the Scottish Society of the Prevention of Cruelty to Animals, or Post Office, that any part of their report was open to doubt, then that should be brought to the attention of the Procurator Fiscal in the body of the report. Is that the safety net then? Is that what you're describing there?
Yes.
And so have I understood this correctly, that it places responsibility on the author of a document to identify anything in his or her document, if there is anything in that document that their writing isn't accurate or open to doubt?
They should make the fiscal aware, yes.
Are they the best person in the world to identify whether what they're writing might be inaccurate?
Well, I can't answer that, but that's what's happened.
You continue, if in any if in this case there had been any doubt as to the accuracy of the data produced by Horizon known to the reporting officer, then of course that should have been made very clear, since it would have seriously affected the decision made by the Procurator Fiscal. Can I understand what you're saying there? It appears to be that doubt as to the accuracy of the data produced by Horizon had to be shown before the accuracy of the data produced by Horizon needed to be checked.
Give me that again, please.
Yeah. Is what you're saying there that doubt as to the accuracy of the data produced by Horizon had to be shown before the accuracy of the data produced by Horizon had to be checked?
No, I didn't mean that.
Okay. What did you mean?
I meant that if the reporting officer had known that there was some doubt generally about the accuracy of the Horizon system, then that should have been the sort of doubt that came to light later on.
I see. If you were relying on data produced by Horizon, or a document which is made up of data produced by Horizon, or an analysis which relies on documents produced on the back of data produced by Horizon, like an audit, to prove that a loss had occurred, to prove that certain transactions had been conducted by a sub-postmaster, wouldn't you have to establish the accuracy and reliability of those data in any event?
Well, when you say at what stage are you talking about? Are you talking about the reporting stage?
Yes. Remembering the prosecution code, which says in deciding whether to prosecute, you must have regard to admissibility, reliability, and credibility. On reliability, if you're relying on data produced by a computer to prove a loss, to prove transactions, don't you have to establish the reliability of those data first?
Well, I think you're entitled to expect that the reporting officer will have satisfied themselves as to the reliability, in the same way that you accept the evidence from a forensic science laboratory that their DNA analysis is accurate and hasn't been tainted. In the same way that you expect a police officer who's operating a speed gun to be satisfied that it's operating accurately. There are certain things that at that stage you simply, almost as a matter of course, accept.
So you'd proceed on the basis of an assumption that the computer was operating properly?
Yes.
But if somebody, a suspect, the defendant, had said the system is not working properly, would that be sufficient to trigger what you speak about in paragraph 11?
It would certainly trigger concerns in my mind.
You go on later in your witness statement to say that no Horizon ARQ data was sought in this case.
I didn't seek it.
Yes, I mean, I think what you say, I've been asked, this is paragraph 24, I've been asked whether any Horizon data, and in particular ARQ logs, was requested from Fujitsu in this case. No Horizon data was requested from Fujitsu.
By me, no.
Or by anyone, so far as you're aware.
Well, I'm not aware of that. By me.
Right, have you seen any positive evidence, even now, that Horizon ARQ data was sought by anyone?
No, I haven't seen any such evidence.
Okay.
But that's not to say that there hasn't been. I just haven't seen it.
Well, we've heard from Mr. Teale and Mr. Grant, the investigators, and they've told us from your chair that no such data was sought in this case.
That's fine.
So let's work on the basis that no ARQ data was sought.
Right.
Were you aware of the facility to ask for ARQ data?
No.
Were you aware of even if you didn't know that it was called ARQ data, were you aware of the facility to ask for information, material evidence, to establish to some extent whether transactions conducted in a branch were attributable to a sub-postmaster?
Sorry, go back to the beginning of that question.
Were you aware, when you were prosecuting this case, of the facility to ask for information for evidence that would establish to some extent whether transactions conducted in a branch were attributable to the sub-postmaster?
No, I wasn't aware as such, but I was aware that if I need to find that information, I would have asked the investigating officer.
What about this? Were you aware of a facility to find out information, to get data, to see whether any system faults had occurred that were material to the transactions that had been carried out or the process of balancing?
No.
Were you aware of something called the Horizon Help Desk?
No.
And so I think it follows that you weren't aware of the facility to ask for Horizon Help Desk records.
That is correct.
And similarly, a body called the National Business Support Centre, the NBSC. Were you aware of that when you were prosecuting this case?
No.
And therefore its records about issues that may have been phoned in by a sub-postmaster concerning Horizon or balancing?
No.
Were you aware, was it revealed to you a species of documents called pinnacles or peaks?
No.
Which recorded faults or suggestions of faults with Horizon?
No.
That either related to an individual specific branch or to a type of problem or to the system generally?
No.
Okay. And was it revealed to you that there was a species of documents called a KEL, a known error log?
No.
That recorded, amongst other things, known bugs, errors and defects in the Horizon system and the steps that might be taken or had been taken to seek to resolve them?
No. Remember, that's this stage I'm only reading the report.
Yes.
And I think we've got the report here.
Yes.
I don't think any of that was mentioned.
No.
And if it wasn't mentioned, then I wouldn't know about it.
And I think that applies to the rest of the prosecution as well, all of the categories of material that I have mentioned, ARQ data, records of calls to help desk, records of calls to the NBSC, pinnacles, peaks and KELs. They weren't revealed to you in the course of the prosecution at all?
No.
You tell us that the investigation appeared to have been conducted thoroughly and fairly.
As far as I could see at that stage, yes.
And everything was addressed promptly and properly by the Post Office?
It seemed to be, yes.
Thank you very much. I wonder whether we can take a break there, please, until 11:30.
Yes, of course. So we'll resume at 11:30.
Thank you very much.